Good morning, ladies and gentlemen. I'm here early. I said I was going to be starting in 9. We're almost there, a little bit after. We're going to try to finish this Aileen Wuornos trial this morning, and we'll be starting something new next week. Come hang out. Let's go.
I get my hair out of my face while I'm doing this.
Therefore, these proceedings are now
putting somebody who was raped.
Let's rock.
Boom. We're live and in living color on the YouTubes. What's up, everybody? Welcome in here. Murder Church. Last episode of Aileen Wuornos is happening right now. We're going to go through everything. So I want to start at 9 this morning. A lot of times I'm starting at 10 now. For the fact that I do this late night Saturday night stream now for Wrestle Plunge on Twitch. But today we're going to finish this thing because next week we're going to be starting a brand new Murder Church season. And before we do that, we got to pick a brand new trial. And we're going to do that together next week. I'm going to get some of these pro se ones together, and then I'm going to get a few others together. So if you have any that you haven't let me know about that you'd like to see, let me know. We'll get them on a list. And yeah, we will decide next week together with doing a little bit of voting. Try to hype it up. Try to get some people interested. Let me get the chat popped out here. Probably see some people's. It probably takes some people a while to realize I'm even live this early. We've been going live at 10, so we'll see if we get some stragglers coming through here. But in the meantime, I appreciate the folks that are here. Pastor Paige, Sydney, thank you very much. Let's do it. Let's jump in here. We're going to be starting out this morning with Barry Wuornos, the brother of Aileen Wuornos. So interesting. Thanks, everyone. Let's rock and roll.
Ladies and gentlemen, adjourned.
Okay, I'm Barry Wuornos. I'm Aileen Wuornos' brother.
So you were raised by your father and mother, Miss Wuornos' grandmother and grandfather in the same home, were you not?
That's true, but actually, biologically, they're grandfather and grandmother, but legally, we adopted Aileen.
Could you describe your family's lifestyle, the interaction between your parents and yourself and your other siblings, including Miss Wuornos, when they were first adopted and brought into the home until you left for the service?
Well, I would say it was a normal lifestyle. We were pretty straight and narrow family. Very little trouble in the family. While Aileen was growing up, very little trouble from the day we picked her up at, I would say she was around 2 years old, to about 10 or 11 when I left for the service. And that's about all I can say. It was just a normal upbringing for all of us.
Can you tell us some things about your father? What kind of a man was he?
Well, he was kind of a disciplinarian when it came. Are you speaking to discipline or upbringing?
Well, what was your impression of your father?
Muted also. We're starting out great here this morning, but thank you so much for reminding me about the Mel Semi or Bassett. I'm gonna get it together here in a minute. We're cooking with gas here, fellas, ladies.
Father, being brought up as a child.
Well, he was a man of very strong character.
I'm gonna make some coffee.
Gentle man. He was laid down strong rules. but a man you could really look up to.
Was he the kind of man that would beat a child?
Oh, absolutely not.
In all the time that you lived in that house with Aileen Wuornos, did you ever see him beat her?
No, now,
Well, tell us what you observed between the interaction.
Well, when you
between your
said-
father- Yes. Yes. Tell us, if you will, sir, in your own words, the interaction you saw between your father and Miss Wuornos from the time she came into your home until you left for the service. And take your time. Just,
the interaction between my dad and Aileen,
what kind of relationship did they have?
a very good relationship until she reached about the age of 9, 10, and 11. About the time I went into the service, things began to get a little tight with Aileen, discipline-wise. She began, well, the tip of the iceberg there is when she got caught for shoplifting. She liked to toy with fire a little bit and got badly burnt once, but the only disciplines that were ever put down were grounding. And no spankings that I ever saw Aileen ever got, although in my day I got a few myself, you know. But none for Aileen that I ever saw.
Would you describe your grandfather as being an abusive person? Excuse me, her grandfather, your father.
No, not at all. Like I say, I received normal spankings, but the general rule was grounding. You know, you're in for 2 days or 3 days. That was it. Yeah.
After you left the service, did you stay in touch and contact with Ms. Wuornos?
Well, I stayed in contact with my mom and dad and received, you know, various bits and pieces of news about Aileen.
Did your father and your mother provide her with a home, shelter, and food, and clothing?
Oh, yes.
This incident with the fire, did that require any type of medical care?
Oh, yes, yeah.
Was medical care denied to Ms. Wuornos?
No, not at all.
You know how your sister got to the hospital?
No, I don't remember, although I know she did go to the doctor, and for a period of many months, she received salves and a gradual clearing of the incident, you know.
Was your father one of the people that helped to apply those salves and dressings to her and take care of her?
Mom, basically. Mom did that, yeah.
You just
All right, yeah, I'm listening, guys. I'm gonna run upstairs, make some coffee, and I'm gonna take my phone with me, and I'll see Chad as well.
describe your mother for us.
Well, she was, Mom was a very quiet, studious, kind of laid-back woman that, very in the background sort of woman. Very much easier going than my father, and no punishment of any kind ever came from her sector, you know.
Did your father work or have a job?
Oh, yes, yeah.
What did he do for a living?
He worked for Ford for a long time as an engineer, Chrysler as an engineer, and he got laid off from Chrysler, and for a short time he worked as a janitor in a school, and then went on to be a quality control inspector in Beaver Precision in Troy.
Did your dad have difficulty in going to jobs on a regular basis?
No, he's like me, he just doesn't miss any work. He didn't miss any work at all. We were very punctual, and in our upbringing, that's one thing he never allowed, is to slackered as far as going to work or school.
Wanted all the children to go to school?
Oh, absolutely. Yeah, he was strong on school. In fact, he's quite disappointed. I started college at Open University and dropped out to go to the service, and he was a little disappointed in that. He wanted me to see that through, but he was big on education. Yeah.
While you were growing up, your mom and dad and Aileen, was there another sibling also in the house? Was that Keith?
Keith, yes,
Were
Eileen's
any-
brother.
Was Keith or Aileen Wuornos treated differently from you and your own sister?
Not that I ever saw, no.
How about disciplinary-wise?
No. Well, I can only relate this incident. Now, I said I received a few spankings in my day, and there were times when Dad would discipline Aileen, and once I remember he was going to spank her. She brought up the fact that she was adopted. She said, "Don't lay any hands on me. You're not even my real dad." From that moment on, I never saw any attempt on part of my dad to physically even spank Aileen. But there were groundings. but that was normal in our family.
Do you know when she first learned that she'd been adopted by your mother and father?
I can't give you a date on that. The only thing I can say is she brought that up during that time, and she was 10 or 11 at that time. How long before she knew that, I can't really say.
Were you ever contacted by a Dr. Mann, a Dr. Toomer, or a doctor, excuse me, I'm trying to think, Dr. Mann, Dr. Toomer, and I'm losing Dr. Croft, excuse me. Any of those people ever contact you or try to speak with you?
None of those names ring a bell to me.
No one ever made any attempts to speak to you as far as those three individuals to learn anything about your family, yourself, your father, your mother, or your background?
No. Are they psychologists or something, or what?
You don't even really know who they are because they
No,
never tried
I
to
have
reach you.
no idea. No.
Thank you, sir. Nothing
Okay.
further.
Motion may inquire.
How are you, Mr. Wuornos?
Fine.
Don, stand up for a minute. Never? Okay. Do you recall receiving a call from Don Sanchez, an investigator in this case? You may never have seen him.
No.
You recall receiving a call from him and asking to talk to you about Lee's case?
Sanchez?
Yeah.
No, not at all. No.
Who have you spoken to regarding Lee's case?
Well, various reporters naturally have called our house, and I've been in contact with Sergeant Leonard Goretzky, the Michigan contact. Basically, that's and there was a movie producing lady that Jackie somebody, I think Jack was.
Jerome?
Yeah, there you go. We've turned all these people away from our door because we don't want to have any comment to do on it. The biggest contact I've had was with Mr. Goretzky.
Okay. You talked to Sergeant Goretzky,
Oh, yes.
and you told him all sorts of things.
Right. We made a tape interview about Eileen's background along with me and everything else.
Did Sergeant Goretzky tell you why they needed that information?
Well, she had just been picked up for, at that point, I don't think she had been tried with any of the murders involved. I think they told me that she had been involved in some car burglary or something like that. At that night, that's as far as he went.
And you remember talking to a guy named Paget, an investigator from Citrus County, Florida? It was a
Yeah, I believe Paget, Leonard
Taddy,
Goretzky, and Taddy were the one who conducted the interviews with me.
Any of these guys, Taddy, the prosecutor, Paget, the investigator from Florida, or Goretzky, the investigator from Michigan, you said they told you that Lee had been picked up on something?
Yeah.
Did they arrest you?
No.
Beat you to rights or anything like that?
No, absolutely no.
You sat down with them for a while, they turned the
Sure.
tape recorder on, you talked to them about Lee. Did you ever ask them to let you talk to Lee?
No.
Why not?
Well, there was no reason for me to talk to her.
How about that she's your sister?
Well, no, it never occurred to me, no.
Did you ever?
Because she had been in various troubled times, and I figured here's another time she's in trouble, and I just cooperated. Simple as that.
Did you ask, say, Tony Taddy, how Lee was doing?
I think I asked him if she was incarcerated at that time or in jail, but beyond that, no.
Did you ask Goretzky how she was doing, or Paget?
No, I don't believe so.
Did you ever ask any of the three of them to let you talk to Lee's lawyers?
Outside
I-
the scope, Your Honor. Go ahead. We're over there, Jack.
I'm sorry?
Oh, should I answer that?
Yes.
Okay, well, I didn't even know she had any lawyers at that point. I mean, there was no mention of that.
You say you don't remember a few weeks back or a few months back getting a call from one of the investigators working for us.
Objection asked and answered.
Sustained.
Lee's mother was your sister?
Yes. Oh, Diane?
Yeah,
Yes.
Diane.
Sorry.
What was she like?
You mean now or?
Then, when Lee was born?
Oh,
What was she
when,
like?
oh, she, just like a normal older sister. She had run-ins with her first husband, naturally, and this what led to the abandonment of Aileen, and we picked her up at age of 2, and she was in trouble at that point, but before that she was a model student at Troy, but when she got mixed up with Leo Pittman, her life took a turn for the worse.
She was not in the household with you, Lori, and Lee and Keith.
No.
Where was she?
She was with Leo and in various stages of separation or with him, or it was an on and off marriage, and Leo was, well, you know probably as much as I do about it, yeah.
When she was separated from Leo, where was she?
Where was she? I have no idea. I don't know.
Do you remember Lori asking where she was?
At that time,
Yeah.
Lori was just a little girl at that time.
Okay, you're about 9 years older than Lee, right?
Then
Then
Aileen?
Yeah.
I'm about 12 years older.
About 12 years older than she is? What about Eileen's father? What was he like? Leo.
Leo?
Yeah.
I know very little of Leo. I remember a few incidents as he was trying to date Diane, and he was quite a rousy individual, and he used to tear up and down the street and hang around with quite the hoods of the neighborhood. And he was pretty abusive. One day he threw me down and threatened to choke me if I wouldn't give a message to Diane, and he was generally a criminal type, you know.
Do you know how he died?
Yes, I do.
How did he die?
I heard he was sent to prison and later hung himself.
How old was Diane when she left the home?
I think this is a quick guess, but I think she was 15 or 16 when she got married. I think, or yeah, somewhere around there.
And then how old was she when Keith and Aileen were sent back to your parents?
Well, that would have been 2 years later. Yeah.
But Diane did not come back, right? Once she left the home, she never
No.
came back.
No.
Did you yourself have contact with Diane?
Over the years?
Yeah, well, between the time she left the home and the time she sent Lee and Keith to her grandparents?
Oh, no.
No contact with her at all?
Oh, well, the time she got married and the abandonment between that time? Oh, yeah, I saw her on and off, yeah. I'm sorry, I misunderstood you.
Did you find out why she didn't keep Keith and Aileen?
Well, I'm vague on that because it wasn't discussed much in our family. It was a very sore spot. All I know is it was a troubled marriage, and why she left or how she left, under what condition exactly, I can't speak to that point. All I know is we went one day to pick them up. There they were in the apartment, Aileen and Keith, and we took them back home.
The fire that you spoke about a little
Yes.
while ago where Lee was burned, you weren't at home when the fire happened, right?
Yeah, I had to be at home, yeah, because I remember her face being badly burned. That was just before I went into service.
Were you at the fire itself?
No.
So you don't know how it started or anything? like that?
Only from hearsay from Lori. That's it.
Lori was at the fire.
Yeah. Mm-hmm.
You also testified that your dad, Lee's grandfather, was a disciplinarian.
Sure. Yeah.
That the home had strict rules.
Well, no more strict than anyone else, but we did have rules, yes.
Do you remember an incident involving a cat that your father drowned?
No, I sure don't.
You had left the home at that point.
Objection, Your Honor.
Withdrawn. How old were you when you joined the military, sir?
I think I was 22. Pretty sure I was that guy.
You testified that, well, withdrawn. Did Lee do well in school?
Yeah, I think she always did well in school until she reached, well, I would say it'd have to be around the 9th grade, and she had great artistic ability. And during her formative years at elementary and that, she was a very good student.
Was she getting good grades?
As far as I know, I never experienced anything bad about her report card, what I can remember.
Were the school people indicating that she needed counseling, as far as you know?
Not while I was at home, no.
Did you ever hear your mother and father discuss any problems that Lee was having in school?
I believe I heard something just before I went into service on truancy. There was a few questions on truancy.
Do you ever remember them discussing whether Lee needed a hearing aid and whether the school people were saying anything about that?
No, never heard anything about that.
Was that a concern for anyone in the family as far as you recall?
It's never been brought up as far as I know, yeah.
Do you recall them ever discussing Lee needing to be seated in the front of the classroom or needing glasses? Was that a concern for anyone in the family?
No.
And do you ever remember anyone in the family discussing whether Lee had been given medication in the school, tranquilizers and things like that? Anybody in the family discussed or was concerned about that?
No.
Do you remember anybody in the family discussing whether Lee was having trouble understanding things at school and whether the people at school were saying anything about that?
No, if anything came of that, it was after I...
Excuse me. Objection, Your Honor, as to time frame. This is after this man had left the home.
Lay a prejudice status.
He had already left the home at that time.
When did you leave the home, sir?
like I said, I was 22 and I joined the service in January of '67.
And the council could establish that would make Aileen 12 years old.
Actually, I don't think it was that.
11, thank you. I defer.
January 67 is 10, actually.
January 67.
Yes.
11 months later.
You don't recall anyone in the family discussing any problems Lee was having in school?
No, I thought she was doing quite well while I was at home, yeah.
Now, in January of 1967, do you remember anybody in the family discussing problems that Lee was having in general? Up until January 67.
Oh, no. Oh, well, let me take that back. There was that shoplifting deal with my mom at Kmart and the fire are the only things that I had heard before I went into service. And then I heard there were while I was in the service, through letters and that, I heard she was getting into trouble, other trouble.
Let's not talk about when
Oh,
you were in the
before
service.
that, those are the only two incidents I can remember.
Before you went to the service, you knew about the fire.
Right.
The shoplifting thing you're talking about, was
Right.
Keith with Lee for that one?
Was Keith with me? I don't know. I don't remember. All I remember is Aileen was chastised for that,
Do
yeah.
you remember if Lori was with her?
I don't think so.
Do you know whether Lori was with her?
No, I don't.
I'm sorry, I didn't hear the
Do you
question.
know whether Lori was with her?
No, I can't confirm that, no.
And when you left, she was 10 years old.
10 or 11, I would say, yeah.
And by the age of 10 or 11, when you left, those are the only two things you heard discussed that would at all fall into the category of problem.
Exactly. Yeah.
When was the last, with John? When you returned from the service, do you remember Lee trying to visit your family or visit your home? On a couple of occasions?
I'm sorry?
On a couple of occasions?
Not that I can remember. I know she drifted in and out, you know, her and Keith were, you know, on the streets quite a bit, and that's about as much as I remember her coming back.
And you and Lori were not Diane's children, you were her brother and sister.
Exactly, yeah. You don't have any water here, do you?
Go up and get my coffee in a
Glass of
minute.
water, please.
It's taking a while. This thing's gonna be over in a minute. Thanks again, everyone, for hanging out. I appreciate it.
What did your mom die of?
I think it was a liver disorder.
Okay, what-
She was anemic and, excuse me. She was anemic and had trouble retaining iron in her system, and it affected her liver very bad, and I think that was one of the causes, even on the death certificate, deficient anemia and liver disorder.
Okay, was it sclerosis of the liver?
No.
What did your father die of?
My dad died, death certificates is accidental carbon monoxide poisoning.
How did that happen?
I came home one day and I parked in the garage, went downstairs to see him. He lived with us in Troy, and he
down
wasn't
here.
there. And immediately I was kind of scared because if he wasn't upstairs where I saw with my wife downstairs, I went back in the garage and he was dead behind the wheel of the car. And I didn't even see him when I pulled my car in right next to him.
Did your dad drink?
Yes, he did.
Did he drink often?
I would say he had probably one bottle of wine a day. Never more, and hardly, well, I won't say less, because he had periods where 2 or 3 times in my lifetime where he tried to dry out completely, and he did for like a year at a time. But he would complain, he had bad pains in his legs from the war. He had some war wounds, and he always claimed that the wine is the only thing that could ease that pain. So, but it never affected his work record or anything.
You do not currently reside in the state of Florida, correct?
No.
How did you get here to report today?
I was flown in.
Who flew you in?
These gentlemen here.
Did you ever ask these gentlemen here to let you speak to Lee?
No.
Irrelevant, Your Honor.
Is there objection?
Objection, Your Honor.
Did
You
you
asked
ever
a
ask
question.
these gentlemen to let you speak to Lee's attorneys?
Objection, Your Honor. Counsel could have spoken to this witness. He's had his name since February of last year. He chose to do so.
Well, for this trial on the speech, Your Honor, it's not even what I was asking about.
Will you object, Mrs. Snee?
Thank you,
To
Judge.
that question you
I'm sorry?
asked. Add to the question you asked.
Thank you, Ms. Warren.
Any further?
No, sir.
Thank you, Mr. Warren.
Okay, stand down. Hey,
Rolling into the judge sitting there and looking strange. What is he doing? What is this son of a bitch doing right here in front of us? Counsel and the judge discuss jury instructions outside the presence of the jury. So we're getting real close here. 16 minutes. We got jury instructions. I'm going to run and make this coffee. And we're getting there. We are getting there. Let me take this witness name off the screen. Might be the last one. Yeah, so Eileen's father drank a bottle of wine a day for leg pain. I mean, I get it, I guess, honestly. Yo, Leah, welcome in here. Barry was Eileen's brother.
Accused Aileen Wuornos,
Joyce and jury
attorneys Billy
instructions.
Knowles,
The third
and
one.
Tricia Jenkins. The state was represented in this matter by David DeBoer. Counsel, you've had an opportunity to see the proposed verdict forms, not verdict forms, but the proposed instructions to be given that are taken from the standard book. And we will start down to the point where it says the aggravating circumstance should be given. Is it the request of the parties that we omit those items that are not aggravating factors? And I'll get back into it in just a moment. You do...
Yes, sir. We would make that request. Now, we also have specific issues as to the aggravators themselves when we get to them, but that would be, I think, the general request. Mr. DeMore, you as well.
All right, now you have seen these, and we'll go through them paragraph by paragraph and state your objection.
Yes, Your Honor. As to paragraph 1, sentence 1, there's the language in there that indicates her crime. We would request the language, the crime. We think her crime suggests to the jury that the court may have an impression and would be improper under the Eighth Amendment.
Let's say the statement.
On the standard instruction, Judge, the gender is there. We ask the standard to be conformable.
Secondly, Your Honor, there are a number of Caldwell versus Mississippi-based objections. Caldwell, C-A-L-D-W-E-L-L versus Mississippi-based objections. The first as to that would be in paragraph 1, as you have been told, the final decision as to what punishment shall be imposed is the responsibility of the judge. And then there's further language in that same paragraph relating to an advisory sentence. We would request that Your Honor not give language that suggests to the jury in any way that diminishes their sense of responsibility pursuant to Caldwell versus Mississippi and the Eighth Amendment. And we would also request that if Your Honor will be giving the language and instructions in their current form, that Your Honor add at the end the language, your recommendation is important and will be given great weight in imposing sentence. We feel that although that does not ameliorate the effect of the Caldwell problems with the prior language, that at least indicates to the jury that there is some importance to their verdict.
All right, even though it is outside of the standards, I will give it because I put it in my proposed instructions for you to review. Your other objection?
A wealth of Florida Supreme Court case law going back to Dixon, Provence.
Now we got caught.
Tons of other cases, I won't rattle them off, indicating that you should not double aggravating factors in this manner. And it is just as improper to double them before the jury as it is if the court were to do it independently. And we would request that the state either select one of these aggravators or that Your Honor not instruct them both. And as it currently stands, we would object to the giving of this instruction on 8th and 14th Amendment grounds. Moreover, as to the pecuniary gain aggravator, an instruction is necessary defining for the jury what the heightened mental state level is, making that aggravator applicable. And the current instructions do not have that, and we object to that again on 8th and 14th Amendment grounds.
Judge, I think by counsel's argument, he's conceding that the Supreme Court of Florida has already determined that it's proper to give the jury both charges in situations such as before the court. I take it that his argument is that case laws would be improper for the court to double that should you find it. It is perfectly and has been upheld that the jury should be charged on both offenses and both aggravators. We would ask that be done.
Right, would be granted and the objection is noted in the record and overruled. There is one thing I would like to, and I will concede this to the defendant. The standard charge calls for financial gain. The statute says pecuniary gain. Which is the choice of the defense?
The defense would prefer, it doesn't matter much, we would prefer pecuniary.
Pecuniary. All right, the next one.
Next one's really bad.
The next one is a crime for which the defendant's sentence was committed to disrupt or hinder lawful exercise of government. Is that requested by the state?
Yes, sir. I'm sorry. No, I'm sorry. No. I was going to ask that.
Correct. The next request is for which the defendant's sentence was especially wicked, evil, atrocious, or cruel. And you have seen the proposed charge that defines those words.
Yes, Your Honor. We would respectfully object to the proposed grounds on the basis of Maynard versus Cartwright, Godfrey versus Georgia, and a wealth of other Eighth Amendment case law. This instruction is vague, ambiguous, does not sufficiently narrow and channel the jury's sentencing decision, and violates the 8th and 14th Amendments.
Your Honor, the evidence in this case supports giving the instruction we requested.
The next one is the crime was committed in a cold, calculated, premeditated manner. Is that requested?
Yes, sir.
Your Honor, as it currently stands, the instruction fails to provide a sufficient, it does not have a sufficient definitional component comporting with Maynard versus Cartwright and Godfrey versus Georgia. We have submitted to Your Honor proposed instructions, as to the cold, calculated, premeditated aggravator. As to the premeditated aspect of it, we submitted a proposed instruction which seeks, and formally have requested an instruction, which seeks to meet the Florida Supreme Court's discussion in Rogers versus State as to what heightened premeditation is and how the jury should go about considering that issue when dealing with this aggravator. As it stands right now, any jury convicting in a first-degree murder case would apply this aggravator as currently phrased here because there's no definition as to what heightened premeditation means, which the jury can consider. As to the cold, calculated aspects of it, those two suffer from vagueness, Your Honor. In a certain sense, any felony whatsoever can be considered cold and calculated. As to the aspect of lacking a pretense of moral or legal justification, again, definitional language would be necessary as to that as well as to the other aspects of that aggravator in order to meet what the United States Supreme Court spoke to in Godfrey and in Maynard. The Florida Supreme Court has spoken to this issue as well on a number of occasions, including Rogers, and we would object to the giving of this instruction in its current form on 8th and 14th Amendment grounds, and note to the record that we have submitted certain proposed instructions on it.
Yes, sir. I'll rule on those in a few moments. The next aggravating charge is the victim of the crime.
Get it, Sammy, get
Was
it.
a law enforcement officer, and the following was an elected public official, and I assume the state are not requesting those. All right, we will move into the next section of the standard charges. That if you'll follow in your book about if you find that the aggravating circumstance does not justify the death penalty, your advised sentence should be one of life imprisonment without elderly parole. I'll give this to you for 25 years. Now we go into the mitigating circumstances.
Judge, on that one, other than the word advisory, which involves a Caldwell issue that I spoke to earlier, we have no objection to its current form.
All right, and then the aggravating circumstance do not exist. Now, you have submitted some proposed charges, and I'll rule on them later.
Yes, Judge.
In regard to this paragraph.
But as to the burden shifting aspect of those paragraphs, again, it speaks to whether mitigating circumstances exist that outweigh aggravating circumstances. And Your Honor heard the previous argument on the burden shifting and the 8th and 14th Amendment issues. I won't restate it all, but note the objection.
All right. Does the defendant request the charge on significant history?
No, Your Honor, we waive that charge at this juncture.
The next is the crime was committed while the defendant was under the influence of extreme mental or emotional disturbance.
We would request that the court give that charge, Your Honor.
Granted. The next is the victim was a participant in the defendant's conduct or consented to the act.
We would request that the court give that instruction, Your Honor.
The request is granted, the objection is overruled. The next one is about an accomplice.
We would not request number 4.
Will not be given. Number 5, extreme duress or substantial domination of another person.
We would request that one, Your Honor.
I think that will be a doubling again, and I don't know of any person that was dominating her here that I've heard any testimony to.
Judge, we didn't discuss this off the record, but if you want, I can tell you that
Here, on the record.
On the record, Your Honor. First, the language of the statute is in disjunctive. It doesn't say the extreme duress has to come from the substantial domination. It says extreme duress or substantial domination.
I have that.
And given the disjunctive language in the instruction, the mental health evidence that Your Honor heard would relate to a psychological form of duress. Secondly, Judge, the substantial domination also relates to evidence that you heard about the interaction, interplay, and influence between Ms. Wuornos and Ms. Moore. And so we would feel that although it is phrased in the disjunctive, there is evidence to support both of those in this case, and therefore that instruction should be given to that individual.
Salute, welcome in.
That request is denied as to paragraph 5 of the standards.
Please note our objection, Your Honor.
Yes, sir.
Jen, good morning.
Your request is denied.
Right, and I'm saying, please, yeah.
The next one is the capacity of the defendant to appreciate the criminality of conduct.
We would request.
And I'm going to strike the word is and just put in her that you want to look at. I would suggest we leave the word other in. If you want it stricken, I will deny it.
Ms. Jenkins suggests that we leave it in, Your Honor. I would defer to her.
The majority rule, 1-to-1 lady wins.
This one's Tricia.
1-to-1 lady wins. All right. Now, we go to the next paragraph of the standards, the aggravating circumstances. From here on out, the standards are in effect as far as my proposed orders are concerned.
Yes, Judge, and we don't have anything specific until you get down to the bottom. You will now retire. Yeah, and then go. If I may, Judge, just to go through the standards, and then we'll go back to some specific things.
Yes, sir.
On the standard language, the only concern we have is both in the last paragraph and in a couple of references prior to that where the sentence is spoken of.
Deny it, but if you want some demonstrative list to go to the jury, you can use the board.
Okay. Yes, Your Honor, we would request an instruction.
Well, I don't have anything in writing, so I don't know what you want.
On the verdict forms, Your Honor.
Yes, sir. Now on the verdict forms, I believe that you've had an opportunity to see them. They track the wording of the statute and of the rule. The verdict form proposed just leaves off the word without possibility of parole.
I'm sorry, I keep hitting mute. Son of a bitch, my bad. Sorry. I'm going to get it together this morning. This coffee's going to kick in any second. My bad. I have 4 trials on here right now, and Letitia Staunch is one of them. So far I've got Pamela Smart, I've got Daryl Brooks, I've got Ronnie O'Neill, and then I've got Letitia's. And then I really would just like, if we get more than 8, cool, we'll figure it out. Maybe we'll have a bigger tournament. I want at least 8 to make a full-fledged tournament to start next Sunday here on Murder Church. And then we'll go from there. And we'll even start that trial next Sunday. But yeah, I'd like to get a bunch more on here. So
25 years, and that will be added before it's delivered to the jury.
No objections or substantive requests. I don't know if you want to change foreman to foreperson.
Yes, I generally do that. Our original verdict says foreperson.
And Judge, for the record, we would object to the without possibility of parole for 25 years language. We think that...
You want it deleted?
Yeah.
In the verdict form?
Yeah, because it tracks the statutory one.
I will omit it if you know it. It's in the chart and it's in their recommendation. It's in the standard chart.
I think it is in the standard.
Okay.
Just here.
Yes, I'm right.
All right, so I will leave the without possibility of parole for 25 years in the standard. Does the state have any requests for additional instruction?
No, sir. I think I've already voiced my objection to report to victim participation.
Yes, sir. All right. Ms. Wuornos, have you been able to track with us what we're doing here?
Not really.
No. Do you have any
I have
objections to
bad
the
hearing,
thing?
so
Ma'am?
I have bad hearings.
All right.
But
Well, you've had an opportunity to observe us at work, so we will call it a night, council.
Thank you, Judge.
9:30 tomorrow. Now, I think that's going to be up to us about the order of argument. I don't know how you want to do on this. Opening, closing, or opening, closing, middle shot, or what?
My understanding is state goes first, then defense goes, that's all you have.
I'm asking how you want to do it.
It's fine with me.
State go first, defense go last.
I think the discretionary matter of the court.
So just looking here, I don't think the Ronnie O'Neill one is findable in completion. Pamela Smart's good, Daryl Brooks is good, but the Ronnie O'Neill one I'm having trouble finding. I can find clips, but I can't find the entire one. I'm not done searching those.
It is, and that's the reason I'm asking for guidance. I don't want to impose my will on anyone.
We're asking for opening and closing.
Where the state presented.
There we go.
Go ahead, I'm sorry. I thought you were saying something.
Well, no, I wasn't going to say anything.
Clips.
It's typically done, Your Honor. The state goes first, defense goes last when both sides present evidence.
It looks at this.
Not nothing for Republican.
And you have a case here where both sides presented
That's right.
evidence, so.
That's right.
Can't do that one.
That means
Somebody
they have a right to
Ronnie O'Neill was
rebuttal.
Well, no,
Aye,
not in the penalty phase.
Not in the
Right.
penalty phase, Your Honor.
There's no, let me just tell you, there's no statutory requirement that rebuttal be allowed.
I know it.
In general, in these proceedings, where both sides present evidence, you go, one side argues, the other side argues, and it makes sense that the defense gets to argue last, given what you're dealing with in a penalty phase. And that's why the statute does not have a rebuttal requirement, unlike a trial where there are
Right.
different interests.
I'll grant that request. State go first, defense go last.
Thank you.
Your Honor.
Court one's right with jury.
Right.
All right.
We're done, sir. Good night.
Yes, sir. We'll see you at 9:30 a.m. tomorrow.
For your service. No one volunteered.
Muted again, son of a bitch. Penalty phase, closing arguments. He probably read it though also. Let's rock and roll. I'm still looking at these trials here, seeing what I can do and can't do.
Any one of you could have escaped from the fact that responsibility avoided it. You chose to meet your responsibility, and we all thank you. It's always a little uncomfortable deciding where to stand in this courtroom. By design, you don't stand in the Senate because you hear yourself. So if you were too close, forgive us. We want to talk to you. This is the only opportunity I will have. I will be followed by Ms. Jenkins. And then the judge's instructions. I'd like to just briefly talk about the instructions for a few moments and the potential forms of the verdict to help familiarize you with it, although no instruction on the law will come from me or any other lawyer in the courtroom. They come from the court.
Joel Guy was like our season 3. We did Joel Guy, which was fucking crazy.
Judge Blunt only. The form for the verdict is relatively simple. There are two potential. One reads, as to count one, a majority of the jury by a vote of blank, and that must be at least 7, advise and recommend to the court that it impose the death penalty upon Aileen Wuornos, also known as Susan Lynn Bohovic, also known as Lori Christine Grody, also known as Cammie Marsh Green, and the date. The other potential verdict, as to count 1, the jury advises and recommends to the court that it impose a sentence of life imprisonment upon Aileen Wuornos,
All right, I'm going to put Chandler Halderson on here, Sleuthy.
also known as Susan Lynn Bohovic, also known as Lori Christine Grody, and also known as Cammie Marsh Green, without possibility of parole for 25 years. To be signed by your foreperson. Neither verdict need be unanimous. If you do not vote by at least a vote of 7 to 5, then you use the second form. If you do vote by majority, which would be 7 or 12, recommend the death penalty, and that should be good. This is known as an advisory sentence, but carries great weight with the court, and should certainly not be taken lightly in any fashion or respect. I know you won't.
That's what I'm not going to do. I'm not going to put Murdoch on there. I actually covered that one when it was happening, and yeah, I'm good on that.
But only the judge imposes the sentence. Juries do not. Not every murder case, in fact, not even every first-degree murder case is a death penalty case. And your participation as jurors is only a part of a long chain of events that began long before you ever imagined that you'd be sitting here, and will continue long after you've departed and gone back to your normal lives. It begins with a decision by the prosecutor to take the case to the grand jury, followed by a grand jury indictment, which is not evidence of anything, it's simply a charge. And then ultimately it goes to a trial where a jury must find unanimously guilt of a capital offense, which you have done. Then it returns to the prosecutor for a decision whether to continue to seek the death penalty. Again, that responsibility rests on with me. And ultimately to you again for a recommendation verdict, and then on to the judge and on into the judicial system. Your responsibilities are here and now.
I'm going to put this one on here. This is one of the last time we did a voting thing for this. This is one that I put on here, and I remember it didn't win, but I think it made it pretty far. Windshield murder trial. Shantae Mallard is accused of murdering a homeless man she struck with her car and left to die in her garage as he dangled from the shattered windshield. I remember when this really happened and I was a kid. This is 2003. Like in the news, I remember it. Prosecutors contend Mallard is guilty of murder because she failed to stop and get medical help after hitting Gregory Glenn Biggs, 37, on a Fort Worth freeway in the early morning hours on October 26, 2001. Had Mallard sought aid, Biggs could have survived his injuries. The defense argues the crash was an accident and Mallard was too impaired by drugs to act responsible. She let a dude, after she hit a motherfucker, get stuck in her windshield and stay there and die in her garage as she went inside the house. That one's going on the list.
It began in Volusia County, and this matter should end in Volusia County. You're not to look to other jurisdictions to attend to justice in this case. You're not to mitigate or aggravate based upon what some other jury, judge, or court may do if there is ever another jury, judge, or court regarding this woman. Finality for Mr. Mallory's death, her responsibility rests solely and exclusively with regard to the recommendation of this jury. His Honor will instruct you on the aggravating and mitigating circumstances, so you need not try to grope, so to speak, for what should we do, how should we be guided. You will be well guided by the court. You will be told of the aggravating and mitigating circumstances available under law, and there are many more than you will hear about, such as the killing of a government official in the capacity of his duties, and on and on. And there are plenty on both sides. The only ones you need to be concerned with are those which the judge will instruct you with. The state has established and offered proof and evidence throughout the trial, and please remember that includes all of the evidence you've heard since we've begun. Of the 11 possible aggravating factors, we have established beyond a reasonable doubt 6. Any one alone, if in your opinion is sufficient to justify recommendation of death, is sufficient. It's not a numbers game, it is a weighing game as to the weight of the aggravator, not how many aggravators versus how many mitigators, but the weight of each and every aggravator proved and or balanced against the weight of mitigators established. We have proven that in fact, and this is one of the aggravators, that this defendant, Ms. Wuornos, has been convicted of a prior violent felony, armed robbery. That is a statutory aggravator. We have proven, and your verdict is verified, that the murder was committed during a robbery. this case. A third aggravator we've proven is that the murder was committed to avoid arrest. The fourth aggravator we've proven is that the murder was committed for financial gain.
For them to hype up this one that I'm looking at here, I'm looking through the archives here on Court TV for trials, and they always put some kind of, sensational line in front of it. This one's sex, cyanide, and a doctor on the run. Ohio versus Yazid Essay. And I'm probably saying that wrong.
In the process, in this case for robbery, your verdict has confirmed that already unanimously. We believe the evidence establishes that the murder was especially heinous and cruel, showing the total indifference of life, and that the murder was committed in a cold and calculated, premeditated fashion. Premeditation certainly was established by your verdict. The mitigators that you will probably hear about, since this is my only opportunity, I want to address them briefly. One, we believe that they will take the position that Ms. Wuornos was under the influence of extreme mental or emotional disturbance. Number two, that her capacity to know what she was doing and to conform her conduct to the law was substantially impaired because of the mental condition. Those two aggravators are built entirely and exclusively upon her stories. If in fact she sat in the car and got out and killed him with deliberation and not as a result of being attacked and ravaged, which she had already rejected, then the extreme mental or emotional disturbance, which all the psychologists indicate would have been triggered by this attack, if it were true, is not there. The same with regard to her capacity to understand what she was doing. They will also argue that because of her age, she should not be held fully responsible. At what age do our citizens become responsible for their acts? Certainly 34, 35, 33 were responsible. Is there ever to be responsibility? They will also argue something in the realm of victim participation. You have rejected that. In fact, if her story was taken at its first version, the most, if it is even true, that this man did was agree to engage in sex with her. And that certainly does not justify or mitigate a killing. And then there's arguably what we call a prosecutor.
This one sounds interesting, and I think I've seen people mention this one before. The former ice cream truck owner Michael Keatley is on trial for the alleged revenge murders of Juan and Sergio Gutron. On November 25th, 2010, prosecutors say Keatley planned the crime spree after he was robbed and shot 10 months earlier. The incident left Keatley permanently disabled and unable to work. Evidence reportedly found in the defendant's home shows Keatley's obsession with finding the people who attacked him, focusing on a Hispanic person named Creeper, with a K. It was determined the two victims had no connection to Keatley's robbery. That one's going on the list. That one sounds interesting, and they're calling it the Ice Cream Man Murder Trial.
It's called kitchen sink grounds. So they're not statutory grounds. It covers virtually everything else. It's, in many instances, a plea for sympathy based upon a different packaging. Mental impairment is the defense of last resort. If you don't have facts or law to support your case, then as a defense attorney, you may find that some solace in the defense of mental impairment. But under the law, the real question is not whether Aileen Wuornos is a strange person, not whether she has a sour view of the world, not whether she had some unfortunate experiences as a young person It's not whether she's explosive, exploitive, violent, and manipulative, and perverted. She's all of those things. She is all of those things. But the question is whether she understood what she was doing, whether she knew what she was doing, whether she knew what she was doing was wrong, and whether she chose to do it regardless of its wrongness and regardless of the consequences to herself and Mr. Mallory, and with a total disregard for his life, as if it was nothing. The evidence that was presented by the defense, and the burden is never as great on the defense as the state. The state must establish virtually everything by evidence beyond a reasonable doubt. They have a lighter burden. But their evidence, the entire framework of this defense mechanism called mental impairment, almost in its entirety, with a few shreds of arguably supportive evidence, is based upon Aileen Wuornos' story and view of life and herself. Recall that these psychologists really had differing approaches, differing ways of reaching their conclusions, and considerably different opinions on a lot of different things, even as so far as whether simple greeting was an attempt to manipulate people. And that was kind of a light moment, but I use that to emphasize the fact that this is really a field that certainly we can't call science. Don't know that we call it art. I don't want to label it, but it certainly is subject to considerable conjecture and potential for abuse, and fraught with real possibility, if not probability, of the individual feelings of the analyzer becoming the primary focus, because they decide which story to believe, whether or not they believe at all, or whether they believe everything. But what could Dr. McMahon believe? She received no report of a rape during the first 4-hour session that she had with Aileen Wuornos back in early 91. Then in March of 91, after a 6.5-hour session, she gets this first story, which is very consistent with what was told to the police. And then 9 months later, in December, she receives the fabrication that you had rejected in your verdict.
Yeah, I think I'm going to dodge that one. I do know a lot about that one, and I've watched the documentary on it, and it's super interesting to talk about. But let me see how long that one is. It is on here, but I'm afraid it might be too long. Is really why I'm kind of dodging. But let me look at it. Hold on.
The interesting thing about Dr. McMahon, she's the lady who testified first, she came to a conclusion that not one other mental health care expert came to, and that was she could tell if the person was lying by the tests. Not one of the other psychologists or Dr. Barnard.
Yeah, it's just a little bit longer than I want. I'm looking at it right now, and it's 129 videos. That would probably be more than 6 months, I would imagine. So yeah, I'm probably gonna not do that one. But that is, I really enjoy that one. That one's crazy. The documentary is insane. I know a lot of people have different opinions on it. Get a little controversial, you know.
The psychiatrist said that she could tell the person lying by the tests. And she went on to say that if in fact the story she finally accepted, and one Dr. McMahon based her whole opinion on, is the alcohol, rape, bondage story. That's what her whole opinion is based upon. She took that as true. You have not. Dr. McMahon said,
like, I think the owl did it. Like, I can totally see the talon marks in the skull. I really think the owl, honestly, I feel like this story makes sense.
That story is not true, then she would have to start all over again and would probably have a totally different diagnosis. She also went on to say that whether Aileen Wuornos knew right or wrong at the time she killed this man was irrelevant. Very relevant. Dr. Croft demonstrated, I think, the uncertainty in the field for us. Also, the arbitrariness of these designations. He said if a child was 15 years and 1 day old, therefore that person wouldn't qualify.
Right?
We all know that things subject to mental processes are not that cut and dry.
Dude, if you look up owls and, like, they will swoop in and, like, attack people's skulls like that. It's happened tons of times. And those talon marks that she had in her head, I don't know, man. I don't know.
That's where they were locked. He said that she would, in fact, by him, be diagnosed an antisocial personality, except she set no fires.
Morning, Joe. Hope you had a good weekend, brother.
Would have given him the additional indicator.
We can't get much closer. We can't get much closer.
Files verified by the other psychologists, and even on cross-examination, the fires were set before 15, and everyone else found it to be a true one. But he wanted to bring in sexual innuendo. Remember, his specialty is sexual child abuse. That's why he was here. Dirty little innuendo against the family. And that's all it was. Dirty little innuendo. Not supported by evidence, refuted by all the other psychologists, in fact, refuted by Aileen Wuornos herself. He went on to say that he would not find her antisocial, perhaps, because she displayed a conscience, and then I cross-examined him on that issue. The fact is, he said that the story was not true of the alcohol rape. Can we just call it that without getting into details? The alcohol rape. That it was not true of the effective diagnosis. Then we had Dr. Toomer from Miami. He told us that the biological mother died of cirrhosis of the liver due to alcoholism. Well, the biological mother is still alive. And in fact, he was talking about the grandmother. But they were trying to tie a genetic chain. That through genetics, this woman is what she is. In fact, the son of the woman who raised Aileen Wuornos came in and told you that it was not cirrhosis of the liver, and there was no alcoholism in this woman. Another attempt to smear someone else to get sympathy for Aileen Wuornos. What he did tell us is that he never asked Aileen Wuornos one single fact about what happened. He came in here to give you his opinion as to whether her mental condition affected her behavior, and didn't ask her one single question about her behavior. Not another mental health care expert used that procedure. And in fact, he said it would be unimportant. That in fact, if she had sat there coldly, deliberately, and intentionally killed and robbed, it wouldn't make any difference in his diagnosis at all. She's still a borderline personality. In fact, they all told us that she's borderline personality and had been since she was a teenager. And killing didn't have a whole lot to do with it. And that's precisely the point. Borderline personality didn't have a whole lot to do with it. She lived successfully 34 years in her own fashion. She's in her own way of life, but killed no one until she got a gun and decided that was a better way, the way she wanted to follow. What they told us was that she just doesn't think quite like most folks. Violent, aggressive, angry. Did we need a psychologist to tell us that? Every one of you did that when you heard the evidence. That woman doesn't think like most folks. But that doesn't excuse her from going out and do whatever she wants to do, especially killing Mr. Mallory. Finally, Dr. Barnard, the last to testify, mental health care expert, he was a psychiatrist as opposed to psychiatry. He diagnosed her, yes, she said she had a borderline personality defect, but her primary trouble was antisocial personality disorder. Something found in perhaps 1% of the female population. Everyone, without exception, of the mental health care experts, including Dr. Barnard, agreed that Aileen Wuornos at the time of the killing knew right from wrong. That she knew the consequences of her acts, and she was able to conform to the law, and that she was responsible for her acts, and that she's not insane. That is not, and has not been, nor will it be in dispute. So who is responsible? Aileen Wuornos says that maybe genetics, with no evidence whatever to support that. She says, through the psychologist, basically, that it's in her own testimony, it was her parents in the home that caused it. The evidence from others refute that, particularly the evidence from her brother. Remember, all of these histories that the doctors talk about, how she wasn't treated right, and there wasn't a great deal of abuse even in those histories. With all the abuse that you're spanked 5 times. In today's society, some people call that abuse. Maybe that's why we're in the trouble we're in today. But in any event, the only indication of anything in the home being wrong is Aileen Wuornos' story, fed to the psychologists who came to testify for her. She was disciplined, and she doesn't like that. She doesn't like discipline. She doesn't like responsibility. She even told her foster father, who had taken her in and cared for her just like the other children, "Can't spank me. You're not even my real father." She would even blame prostitution on others, although she told us that she liked the $60 to $100 an hour per event a lot better than 75 cents an hour. And finally, she said Ty Moore was at fault. Must be her, because she was living off my money. Everyone but Aileen Wuornos is responsible, even the victim.
I'll be glad to be done with this guy. I really hate this
laid
dude.
blame.
Cock
He has
sucker.
no voice here except me. This is not a case about forgiveness. You can pray for her soul, but that's not what we're about here today. It is not about mercy. That is not what you hear in the instructions. Mercy is simply another word for sympathy. And that's not what this verdict is based on. We've had this long break, and we've had plenty of time. It's not to be based upon anger or a will to get it. It's based upon the law that you've heard. It's not even about mental illness, because every single mental health care expert that testified, if there appeared to be any mitigation in their testimonies based upon her stories, but they all agreed she's responsible in every sense of the word legally. It's about a troubled teenager who refused to accept responsibility from the start and chose a lawless lifestyle, a cavorting, moralless lifestyle, and ultimately chose to kill. We began with 2 totally different stories. We began with 2 totally different views of the evidence. You're going to hear a totally different view in just a few moments. One view is based entirely and exclusively upon the misrepresentations of Aileen Wuornos. That is the basis for the defense in its entirety, from start to finish. The other view is based upon the evidence, the facts, and the circumstances as revealed by the evidence and the truth. Aileen Wuornos said that he should die because he's cheating on his family. She's a prostitute. Said she had to kill him to make money to pay her bills. Go on to say, because of the age, it made no difference. Had no parents anyway. In her own words to Deputy Hanson, the lady that worked at the jail that wasn't interrogating her for plenty of time for her to say whatever she wanted to say, no, not being cut off. She said, after I shot him, he just fell down and was saying, "I'm going to die. Oh my God, I'm going to die." And Aileen Wuornos, "Yeah, motherfucker. So what? And I shot him a couple more times." It became obscenely simple for Aileen Wuornos to kill. At one moment, Richard Mallory was here. And a few minutes later, by an act of her will, he was no more. It's not that he never existed. It's not that he never breathed and lived and hoped. It's simply that he was no more. By an act of her will, In just 15 or 20 minutes, she extinguished a man's life forever. And all that's left is a few pitiful possessions, junk, the junk of life, all that's left of a man. She told you, you saw her, her words, I'm guilty. I deserve to die. And you know that is the truth. Let your verdict and your decision with good conscience, and with strength, and with integrity, speak the truth. Aileen Wuornos deserves the ultimate penalty provided under the law of the state of Florida. Thank you.
Good morning. Ladies and gentlemen, this is perhaps one of the most difficult tasks I've ever been required to do. I must ask you to save Aileen Wuornos. I must convince you that she should live. It's a difficult task for me because just asking another person not to ask for the life of another human being is so extraordinary. It's so far from the commonplace that all of the knowledge and tools that we use in our everyday life are simply not available to us. It's difficult because how do I explain? How do any of us explain what it's like to see things as Lee does? How do people who are presumably normal, who are presumably unimpaired, how do they understand what it's like to live impaired? How do I make you understand that everything that Lee feels, does, and says is filtered through that disorder, through that impairment? Everything must go through that filter. She is not like the rest of us. Once there was a verdict of guilty, I started trying to think about what to do. I tried to pull together all of my life experiences and the knowledge that I've gained over the last few years to try to assist me in doing this. And frankly, I have found that it's just not enough. I don't know what to do or say to convince you that Lee should live. I only know that she should. You have necessarily learned about Lee Wuornos in a vacuum. Everything that you know, everything that you believe about her has been gained from this witness stand. For a brief moment in time, you got to meet Lee Wuornos under situations that, if you listen to the testimony of the experts that came in here, was very, very stressful. They told you what happens to Lee when she is under stress. I can't tell you what the three of us have learned about Lee over the many hours that we have spent with her. You must decide whether Lee should live or die based on what you have seen and what you have heard in this courtroom over the last few days. That decision will probably be the most significant and most difficult decision that any of you will ever have to make. Please understand that those of us seated at that table understand that. And we appreciate how hard this must be. But also understand when you're trying to make a decision that the laws of this state embrace the concept of mercy. If you feel that Lee is deserving of mercy, you can vote for mercy. Mercy for Lee is life in prison. Ladies and gentlemen, we're here today because late one night in November of 1989, Richard Mallory and Lee Wuornos met on the side of a highway here in Florida. We've all been in this courtroom. We know that that was a tragic, deadly meeting. All of us are asking why, but why did it have to be that? Perhaps the answer to that can be found by going back to that day years ago when Lee, as a young girl, stepped to the side of the road and stuck out her thumb. She had no direction and not a single hope in sight. She carried with her the baggage of abandonment, the forfeiture of a child, of a baby when she was still just a child. She carried with her the inability to figure out how to make it, how to do anything at all to satisfy her basic needs. All of the experts agreed on that. She didn't know how and does not know how to satisfy even the most basic of needs. From one ride to the next, and to the next, and to the next, all the way until January of last year. She traveled through this world, always on the outside, traveling through a place in which she has never, ever had a place. She has been living in a world that to her perception is violent and frightening. From that time way back, when she was a little girl, she has been burdened with an impairment or a disorder that makes her intensely need, makes her intensely afraid of being abandoned and being alone, and yet at the same time causes her to act in such a way that she will not allow anyone to get close to her. The very impairment, the very disorder that makes her need so desperately prevents her from ever having the satisfaction of fulfilling those needs. You heard the doctors talk about what Lee is like and what she experienced. If you will recall, each and every one of them, and that's even the expert, Dr. Bernard, that was called by the state, said that people who suffer from the disorder that Lee suffers from live an ungratified life. They never feel successful. They never feel satisfied. They don't go home at the end of the day knowing that they have reached their fullest potential because she has no idea what her potential is. She doesn't know who she is. She doesn't know what she's all about, and she can't control what she's all about. She's always alone, and she's always frustrated. Dr. Toomer explained it to you, and he said, what Lee is all about is someone feeling that I don't deserve anything good. I don't deserve to be liked. I'm not worthy. And so what she does, because of her impairments, because of her disorder, a disorder that each and every one of the experts told you she had no control over. She didn't ask to be that way. So what she does is when she comes into contact with another person, she's thinking, I'm not any good, I don't deserve their friendship. They're going to be mean to me. They're going to be rejecting me. And she acts out in such a way that will fulfill that prophecy, will validate her thoughts so that she can say, see, I was right.
There we go. True Crime Butterfly, get in here. What are you doing? Good morning. Get in here. I'm going to give you some bells. Giving you some bells. True Crime Butterfly, please make sure you come through next Sunday morning. We're going to be doing basically a trial tournament. I'm trying to get eight trials together. I think I've got 7 so far. If you've got a trial, give me a trial. Send us a trial in chat. I'll look at it and see if it's something that we'll put on the list. And it probably will be, as long as it's not too long. My real thing is length on a lot of these, but send anything you wanted to see, and we're going to put it on there, because next Sunday we're going to do a tournament, and you guys are going to vote, and whatever wins, we're going to start it next Sunday, and that'll be season 8 of Murder Church. But good morning, good morning, good morning.
No one was going to like me. No one was going to want me. Remember what Dr. McMahon said. I think that was a very, very important description of what Lee's all about. She is a damaged, primitive child. Dr. McMahon told you that she has never seen anyone that primitive outside of an institution. But we all know, we've all had the experience of being in this courtroom for the last few weeks. We know that, yes, there was at least one other primitive, damaged person that was not in an institution, and it was Lee.
That was me this morning.
And she was working from one exit.
I've been struggling all morning.
To the next. She was out on the road, fulfilling some basic needs and assisting in supporting her friend, the only friend she ever had, and engaging in a destructive, dysfunctional relationship. You've heard that that's all she's ever had. She doesn't know anything different. All of the experts told you that Lee views this world as a very, very unhappy place, that she feels persecuted, that she feels that people are against her, that she reacts to the stimuli in her environment. She has no control. Everything happens to her. She is a person who thinks that pain and unhappiness is inevitable. She doesn't understand. She doesn't know. She doesn't have the ability to control that. The doctors have all told you that she experiences severe mood swings. You've heard that testimony. You've also had an opportunity to see that. They told you about a person who could laugh and cry and get explosively angry, and who always, always experiences intense emotions. You've got to see it. You've seen it. Remember when Dr. Croft was testifying? Do you remember who Dr. Croft was? He was the gentleman with the beard, kind of salt and pepper hair. He was telling you that Lee is 1 point away from borderline retardation. And she began to laugh. And she began to giggle and be silly, like a little girl. And Dr. Croft explained why that was happening. It's because people that suffer from what she suffers from can never, ever admit that there's anything wrong with them. That they spend their life trying without success to show people that they're all right, that they're okay. They have defenses that they build up. And Dr. Croft said something He said that the reason people like Lee, who suffer from personality disorders and brain impairment, hold on so hard and so fast to their disorders is because of the pain underneath. They can't ever let that pain be exposed. All of the experts explained Lee's life in the terms of she's on a roller coaster, rapidly moving from one moment to the next, from one mood, and no control over it. Laughing in the courtroom, being angry in the courtroom for seemingly no reason, not being able to let anybody help her, not being able to make anybody like her, always turning on the very people that are trying to help her. All of you have seen that in this courtroom. And she has no control of that. She doesn't choose to be that way. What is important about Dr. McMahon's testimony is that she said that Lee, like other people who suffer from personality disorders, see other people coping. They see other people being able to satisfy their basic needs, but they can't figure out how to do it for themselves. So they suffer the anxiety and frustration of realizing, but not being able to do anything at all about it. What you have seen in this courtroom and what the experts have described are human beings like Lee, who within seconds go from depression, laughter but never happiness, and emotional withdrawal. There have been times when it was almost as if Lee was not in this courtroom. You must have seen the times when she had withdrawn to such an extent that you might have wondered, what is this all about? Why? You also have learned that Lee can't control her impulses, and I think all of you have been able to see that. And how frustrating that must be. All of the doctors, all of the experts that testified in this courtroom told you that in forming their opinions, they reviewed investigative reports. They reviewed Lee's school records. They talked to certain people. They read taped interviews of people who had known the family and known what life must have been like back in those days. And without fail, even the state's expert, Dr. Bernard, told you that one of the things that they agreed on, and actually they all agreed, was that Lee came from a dysfunctional family. I think that perhaps the best evidence that Lee comes from a dysfunctional family was her brother, uncle, Barry Wuornos. He was called by the state and he took the witness stand, and he told you that life was good. Life was okay. Dad was great. Lee didn't have any problems. There's never any discussion of Lee having problems, Lee not being able to get along. Then in her teens, yeah, she probably started having some problems, but remember, he was gone. He had left home when Lee was somewhere between 9 and 10. And think about that testimony and then remember what the experts have told you. They have told you that they have reviewed her school records and that her school records show that she could not hear. She was having hearing problems, that the school was asking for help for Lee, and that her mother, the person that Lee has described as being the angel, responded by saying, she can hear. Lee just doesn't want to follow directions. Remember that she has had visual problems since she was a small child. That's documented in her school reports. But Barry said that Lee was fine. Remember that her school records. Now we're talking, we're grade school. Remember, she quit school in the 9th grade. And grade school records show that they were medicating her with tranquilizers to try to make it easier for her to function in a world, in a classroom where she has never, ever had a place. And the brother says, no, Lee was fine, there weren't any problems. Remember what the doctors told you about the cousin, Mr. Lightila, who considered Lee's grandfather to be an uncle that he wanted to spend time with. And they told you that he spent a good deal of time in their home. And he described Lee's grandfather as a Jekyll and Hyde. He described a man who, when he drank, could be abusive and was very, very different than the person that Barry described to you. Remember that Barry, Lee's uncle, brother, ultimately she found out he wasn't her brother, came into this courtroom and testified against Lee in a proceeding in which the state is trying to kill her. He testified against her. What does that tell you about how dysfunctional that family must have been and still is? What better evidence do you have of a dysfunctional family? Remember the subtle things he said about what that family was all about. He testified from the stand, and I wrote it down. Their adoption was a sore point within our family. He described the siblings as Barry and Lori, natural children, were good. Lee and Keith were bad. And it was a sore point in that family. What does that tell you? Ladies and gentlemen, Richard Mallory is dead. And that is a terrible, terrible thing. We are not asking that you forget that. I submit that each of us feel that all of mankind is somehow diminished when we learn that a person has died at the hands of another. I suggest that all of us feel confusion and pain, and we feel like something has gone awry. We all suffer a loss. We are not asking you to forget that or put that aside. Richard Mallory is dead, and he should not have died. What we are asking that you do is to consider the circumstances of his death and consider Lee's involvement in light of who she is, in light of her history, her lifestyle, what she was perceiving. Do not evaluate Lee's actions on that night in terms of what another person may or may not have done. This is about Lee. That is what these proceedings, these second phase proceedings, have all been about. This is about Lee. Lee, who dealt with her experience with Mr. Mallory with all the sophistication and understanding and insight of a damaged, primitive child. Do not judge her by what another person may or may not have done. The experts explained to you, or tried to explain to you, who Lee is and why she responded the way she did back in that early morning hours of December 1st of '89. They've all told you that she suffers from minimal brain damage. They've explained to you that her disorder causes her to live an unfulfilled, frustrated, paranoid, persecuted, unhappy life. And I want to make sure that you understand that we are not offering these as excuses. We are not telling you that she's not responsible. She told you she was responsible. She killed him. But understand, in her mind, by her perceptions, she thought she was in danger and that she was threatened, and it was the only thing to do. These, again, are not excuses. We offer them as explanations and reasons that you can consider when trying to make a decision as to whether or not Lee should live or die. They're not excuses. There is no excuse. And we are not asking you to forget Richard Mallory. All that we are asking is that you take all of this into consideration before you make your decision. We all deserve that. You, as well as everyone that's been going through this procedure. You need to know the person before you can make a decision like you've been asked to make. The judge will instruct you that if you are reasonably convinced that Lee was under the influence of extreme mental and emotional distress at the time that Richard Mallory died, that you can consider that a mitigating factor. You can consider that as a reason to vote for life. The judge will instruct you that if you find or are reasonably convinced that Lee's ability to appreciate the criminality of her conduct or conform her conduct to the requirements of law were substantially impaired, that is something that you can consider as a mitigating factor, a reason to vote for life. You will hear that you can consider virtually anything about Lee and the circumstances surrounding this offense as a reason to vote for life. Mr. Tanner, in his closing, told you that mental impairment is a defense of last resort. It's what defense lawyers do when they don't have anything else. Well, that is not true. Defense lawyers take their cases as they come, and they have a moral and an ethical obligation to raise those defenses that are apparent. Lee is impaired. She's dysfunctional. She suffers from a personality disorder. We, yes, raised it. And we raised it because it was proper, because it was right, and because it was our obligation to do so. It is not a last resort. It is the truth. Mr. Tanner told you that, interesting, isn't it, the way the experts all have a different way of, a different approach to handling the same situation. Recall their testimony. Was it really so different? But most importantly, recall that they all came to the same conclusion. Remember that the doctors said that what really happened, the truthfulness of Lee's description of what occurred on that night, was not really relevant. What was important in light of her dysfunction and her impairment was what she perceived. That's what was important. And And they told you that without even knowing the facts of the case, their diagnosis would be the same. Mr. Tanner tried to diminish Dr. Kropp's credentials and his credibility by telling you that the reason he was called is because he is an expert in sexual dysfunction. Dr. Kropp, if you will recall, has had years and years and years and years of experience in forensic psychology. He told you that as a subspecialty, he dealt in sexual dysfunction. Well, certainly, he had an opportunity to evaluate someone who fit into both of those categories, and that is why he testified in this courtroom. Again, please understand that these are not excuses. There is no excuse. They're reasons. Reasons for you to consider when trying to make a decision as to whether or not Lee should live or die. Do not be deceived into thinking that life imprisonment is not punishment. I suggest to you that one of life's ultimate gifts is freedom. I suggest to you that if a person were locked forever in, let's say, a mansion, that they would suffer agony every time they looked out the window with the knowledge that they could never go outside again. Consider the prospect of terminal confinement. The judge will instruct you, and you will hear that a sentence of life imprisonment is a sentence of life without possibility of parole until after serving 25 years. That is a mere possibility. Life in prison is severe. Every second of every minute of every hour of every day of every week of every month of every year, Lee will be confined. Someone else will tell her when to go to bed and when to get up. Someone else will tell her when and what she can eat. Someone else will tell her what she can read. When she longs for the comfort of human touch, she can't have it. She will be separated forever from the freedom that she has known since she was a young girl and began to travel freely across the country, sadly unrestrained by the restrictions that keep all of us so close to home. She has been free out in the open for most of her life. She will go to sleep every night in a metal cage, surrounded by the sorrow, the heartache, and the bitter loneliness of others. If she's lucky, she'll have a window. If she's real lucky, that window will give her a view instead of just more metal bars and razor wire, will give her a view of the world outside. And every time she looks at the outside world, she is going to remember what she did to lose it. Her longing, ladies and gentlemen, will always, always bring her pain. Lee lost her freedom in January of last year. I suggest to you that, as with all human beings, though, she has maintained some degree of hope. I suggest to you that there has always been the belief that somehow, and it was a childlike belief, somehow everything will be all right. Well, over the last couple of days, Lee has had to accept that nothing will ever be all right again. Ever. When she leaves this courtroom for the last time, she goes without hope. Whether the sentence is life imprisonment or death, Lee has lost her life. Even if you are merciful, you will simply be giving her the mere right to exist. Please go back there. Please go back and decide that that is punishment enough. Thank you.
Aileen Wuornos, also known as Susan M. also known as Lori Christine Brody, also known as Emmy Marjorie, for her crime of first-degree murder. As you have been told, the conversations as to what punishment should be imposed is the responsibility of the judge. However, it is your duty to follow the law that will now be given to you by the court and render to the court an advisory sentence based upon your determination as to whether sufficient aggravating circumstances exist to justify the imposition of the death penalty and whether sufficient mitigating circumstances exist to outweigh any aggravating circumstances found to exist. Your recommendation is important and will be given great weight in imposing the sentence. Your advisory sentence should be based upon the evidence that you have heard while trying to guilt or innocence of the defendant, and the evidence that has been presented to you in these proceedings. The aggravating circumstances that you may consider are limited to any of the following that are established by the evidence.
All right, we're skipping the rest of this. This 6 minutes of him rambling. He can suck my dick. All right. Closing arguments. I think we're in the end here. Verdict and sentencing. 30 more minutes. Let's go. Let's finish this strong.
Yes, we need questions.
Yo, Salty Slurs, what's up?
7th Judicial Circuit in and for Volusia County, Florida. Case number 91-257. State of Florida versus Aileen Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Grady, also known as Candy Marsh Green. As to count one, a majority of the jury, by a vote of 12-0, advise and recommend to the court that it impose the death penalty upon Aileen Wuornos, also known as Susan Lynn Blahovic, also known as Lori Christine Brady, also known as Candy Marsh Green, dated at DeLand, Volusia County, Florida, this 30th day of January, 1992. Pamela J. Mills, foreperson.
Ladies and gentlemen of the jury, we're going to ask each of you individually concerning the advisory sentence. It is not necessary that you state how you personally voted or how any other person voted, but only if the advisory sentence is read was correctly stated. Madam Clerk, will you please vote?
Yes, sir. Do you, Mrs. Staton, agree and confirm that the majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Farrell, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mills, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. DeGainer, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mrs. Mathis, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Teresa.
Do you, Mrs. Walters, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes, I do.
Do you, Mrs. Wiley, agree and confirm the majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Flowers, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mrs. Bogan, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Watley, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk? Do you, Mr. Oransky, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Do you, Mr. Bashal, agree and confirm that a majority of the jury join in the advisory sentence that you have just heard read by the clerk?
Yes.
Thank you all.
Any further requests of your charge?
Nothing by the state, Your Honor. Thank you.
No, Judge, thank you.
Ladies and gentlemen, I want to express to you and thank you very much for your time and consideration for this case. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occur in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that juries' deliberations, their discussions, and their votes should remain their private affairs so long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to them. A request may come from those who are simply curious or may seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. With those instructions, the jury is in recess and discharged for further obligation and responsibility herein. Sentencing is scheduled for 9:30 a.m. tomorrow morning. Mr. Pettit, you'll escort the jury out of the room.
Judge, before you leave, we would renew all previous applications and motions and extensions. Thank you, Judge.
The order to deliver here by that time. Recess, 9:30 tomorrow.
Thank you, Your Honor.
Circuit Court in the Court of the Seventh Judicial Circuit is now in session. The Honorable Judge Uriel Blunt Jr. presiding. Please be seated. Quiet in the courtroom.
Yeah, those streets too.
Versus Aileen Carol
All
Wuornos,
streets,
also
be
known as
careful.
Susan Lynn Blahovic, also known as Laurie Christine Grody, also known as Kemi Marsh Green. The court is prepared for sentencing. Does the state have any witnesses like to present at this time?
Your Honor, we have no witnesses. May I make a brief statement?
Yes, sir.
Your Honor, I'm not going
He's just like, na 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 boo boo, we beat you.
to insult the intelligence or the wisdom or the perception of this court by going into
That would be
any type of
What
a
a mess.
detailed recounting of the facts and circumstances which brings Aileen Wuornos before this court at this time in this county. I would like to discuss just for a moment or two a couple of aspects of the law and why, in fact, the state is urging the ultimate penalty permissible under Florida's law for Ms. Wuornos. First, I say to you sincerely that this is probably, for every prosecutor, the most difficult assignment that our office faces, and that is the studied and considered decision to first ask the citizens and then ask the jurist to permit the law which requires the forfeiture of a human life to be activated against another citizen. It is not only of great and considerable legal weight, but I can tell you from a personal standpoint, and I speak for my staff, it is of great emotional drain upon all of us involved in a case like this. Nonetheless, the people of the state of Florida, through their elected
All right, I'm gonna run his bathroom. I'll be right back,
and
guys. This guy's gonna ramble for, it looks like,
through
literally fucking 30
well-documented and
minutes.
voiced opinion polls over the years, as the people of this nation believe that there is a place in our society, a necessary place in our criminal jurisprudence for the death penalty. Rare are the cases of murder on the grand scheme of the number of murders committed nationwide in which the death penalty can be fully and unequivocally justified. This is one of those cases. The aggravating circumstances, I'll not recount them. They were argued and the court instructed upon them, have been proven, Your Honor, beyond and to the exclusion of any reasonable doubt. The unanimous verdict of this trial jury, and I can say this, that they took the time to deliberate and return a unanimous verdict, which I think is a clear indication of the completeness of the evidence and the propriety of the sentence of death. I would ask you to not only sentence Aileen Wuornos to be electrocuted, I would ask that with regard to the additional sentences that the maximum penalty be imposed. We know that under the law, the 3-year minimum mandatory as a part of the robbery sentence is called for by statute. No exception for that, even in a murder case where a weapon's used, and I refer specifically to Chapter 775. Under the case law, and I cite Williams v. State, and I have a copy we've provided already to defense counsel, Your Honor. The imposition of the minimum mandatory is appropriate, and that is at 517 Southern 2nd, 681, Florida Supreme Court, 1988. Also,
Even if the weapon was a part of the statute?
we believe that is correct, Your Honor, under the Williams decision. May I hand you that case? Defense counsel has already been provided these cases. In addition, we're asking you to depart from what the sentencing guidelines, which I believe has been one of the greatest impediments in the state of Florida to the fair and appropriate administration of criminal justice, and has directly resulted in the diminution of the respect for the bench and for the law in this state. Nonetheless, we are still bound by them, and we, and certainly like yourself, Your Honor, will abide by sentencing guidelines so long as they remain a part of our law.
Boo.
But a
Boo this
departure
man.
is appropriate in this case from what the guideline sentence would permit
Brooklyn.
to a sentence
How you doing?
Brooklyn. Statute would allow, and that is life imprisonment. And for the authority of that, I would refer, Your Honor, to the state case of Hansbrough v. State, 509 Southern 2nd, 1018, as cited in Rutherford v. State at 545 Southern 2nd, 853. And if I may also provide the court with that case. Case essentially indicates that the forms that the legislature and committees developed under the sentencing guidelines provisions of the law simply don't include a category for a conviction of murder in the first degree to be considered at the time. And under the cases cited, the Supreme Court has upheld, in effect sanctioned, a departure for a sentence exceeding the guidelines up to the maximum statutory allowable. Also, if Your Honor please, with regard to the legalities of where we are for a moment, we would ask you to retain jurisdiction in this case for several matters. One, count 3 was severed at the bench just as the jury selection began. We would ask you to retain jurisdiction until count 3 is disposed of. There may come a time that discussions between ourselves and the defense will result in a resolution without litigation. We certainly hope that. We can only offer what we believe would be a fair resolution. We will do that at some time in the future. In addition, the state of Florida and the people of Volusia County particularly are entitled to reasonable and full cost assessment. We have not yet had an opportunity to compile those figures in their entirety. The bills from the mental health care experts have not been submitted.
Imagine being the person going to death row, be like, I could give a shit about the cost. I'm not going to be here.
Bills for expedited depositions that became necessary because of the lateness of some of the experts' testimony, including their refusal to honor subpoenas from this court, resulted in many late-hour depositions and expedited printings of depositions. So we cannot come to you with those figures at this time. I'd ask you to retain jurisdiction for that. And in connection with that, the rule to show cause motions which have been filed, which we don't want to argue or present at this time, with regard to Dr. Elizabeth McMahon and Dr. Jethro Toomer for their refusals to comply with subpoena. Not meant as a vindictive measure, Your Honor, but only to hopefully bring an orderly procedure to cases in the future where we deal with that particular profession, and more specifically, those particular professionals. The housekeeping matters behind, I would only say in closing, this is the only time that I've stood before this particular jurist and asked you to enforce, uphold, and pronounce a sentence to take another person's life. I don't do it lightly. I can tell you I do it with a heavy heart. Aileen Wuornos has come into this courtroom with an utter disregard, continuing for the truth, with an utter disregard for the destruction she has wrought upon her victims, and with a continuing utter disregard for even the reputation of her very family, her deceased mother and father. Her acts of murder and of total, absolute, unwavering determination to avoid and deny responsibility continue even to this date. I ask you to sentence her to die in Florida's electric chair.
Mr. Tanner, do you have a guideline score sheet for me?
Yes, Chair. These two. Yes, Your Honor, I do.
Has a copy been made available to counsel?
That's what I was asking. Has the counsel copy been made?
Your Honor.
May we step out and make a
Yes,
copy?
sir.
I apologize.
Well, let them view that one, then we can follow it.
That copy is.
Ms. Wuornos, when I have completed my task here today, you will begin the first day of the rest of your life. The curtain will fall on the tragic drama of the trial of Aileen Wuornos.
Great. We get to hear old turd monster here for Jesus Christ, I don't even know how long, lecture her before her death.
Tomorrow's sunrise will bring the beginning of the appellate procedures as provided by law, and I will return to pasture. You have been convicted by a jury of your peers the offense of first-degree premeditated and first-degree felony murder and armed robbery of a firearm of Richard Mallory. Do you or your attorneys who stand to your side have any legal cause to show why the sentence of law should not now be imposed upon you? Do you have any matters in bar precluding the sentence? Do you have any matters in mitigation of sentence that you would give the court at this time?
We have certain matters we'd like to bring up, Your Honor.
Yes, sir.
First, we would ask that Your Honor hear from Miss Aileen Wuornos.
Certainly. So the court reporter can hear you, will you speak loudly enough and also give her your name?
Yes, my name is Aileen Wuornos, P-R-A-L-L-E.
Your Honor, I'm sorry. I was going to say Ms. Prelli has certain matters that she would like to relate to the court. I think this is your opportunity to speak.
Certainly.
Okay, Your Honor, my husband and I adopted Aileen Wuornos on November the 6th. We heard in this courtroom 3 expert witnesses in the field of psychology who said that Aileen Wuornos, though 35 years physically, was emotionally and psychologically a child. Dr. McMahon referred to her as the most primitive one she had ever seen other than within an institution. My husband and I have spent as much time, if not more, than all of our experts combined. We are 100% behind their diagnosis, and I would plead for mercy for my daughter's life because she never was given the chance to grow up. She is still a child, as they have said, and there are 2 factors I think that are very important. Her school records indicated, as well as the experts, that Aileen Wuornos, from a very young age, wanted the structure of a very tight family. She longed to have that, a nurturing environment. And the school records also indicated that she was in need immediately of counseling, immediate. Those were never granted. Both of those factors are now present this day in 1992. She has a family that cares about her, that loves her unconditionally, and we are also, Your Honor, if you would give mercy, in this case, we are willing to pay for the professional counseling that Aileen Wuornos should have received as a child. And I just plead for your mercy for my daughter's life.
Thank you very much, ma'am. You may return to your seat.
Judge, as to the show, a couple of technical matters. As to the show cause issue that Mr. Tanner mentioned, we would like an opportunity to be heard on that.
You shall.
I take it today is not the appropriate time.
I think not.
Yes, Judge. As to the proceedings as a whole, we renew our previous motions, objections, and applications. We do have certain brief comments, and I think Ms. Wuornos has certain brief comments as well. You want to go first?
Yes. Okay. First of all, I'd like to say that I have been labeled a serial killer, and I am no serial killer. I've been framed by the law enforcement as a serial killer because of numerous men involved. But what I was a prostitute. And in my prostitution, I happened to deal with a lot of men, at least 200, 250 men a month. And I ran into these men along the way in my prostitution. I do not feel, I was not out there to hurt anyone. I had no intentions of hurting anyone. In my confessions, I stated that 9 times. I stated 37 times self-defense, 39 times that they raped or beat and then begin to rape and had intentions of killing. And what I did was what anybody else would do. I defended myself, which everybody has the right to defend themselves. And I had no intentions of killing anyone. I would not do that. I'm not that type of person. Anyway, what I'm trying to say here is that while I've been through this 2.5 weeks in the courtroom, I told you that I was raped, and that is what happened. And that is what happened with all other cases that I'll be involved in and discussing. And These people did a violent attack on me, and I did what I had to do to protect myself. Now, I'd like to point out one other thing, is that the law enforcement has framed me as serial killer purposely for books and movies. And I have been, since I've been incarcerated a year in jail, have gone through a lot of physical and mental abuse, which I felt is being a conspiracy through the law enforcement. And I also believe the law enforcement and the state attorneys have a conspiracy here. And I have to say another thing, for as far as manipulation was talked about yesterday in the courtroom, I believe State Attorney Tanner was the one manipulating the jury, which he had made a whole lot of things up. Things were just made up at the top of his head, were not true, and I felt that he lied right through his teeth. I was up in that stand there, and I did not lie. I was coerced into making my confessions. I was threatened that Tyra Moore would be arrested if I did not talk about the confessions. I was also coerced and threatened and told that if I did not answer their questions the way they wanted me to, their questions, and I did it any other way, that she would be arrested. And the questions that they asked me were strictly to implicate me as a serial killer, when every time I talked about a rape, they cut me off, and they had my mind all messed up, where I was hysterical, I was in trauma, and I was alcohol withdrawing. I have been totally under duress and delirium, and I couldn't tell you what happened anyway. I couldn't remember anything under that stress. All I had in my mind was focused on Tyra, which I was trying to clear Tyra, which Tyra knows it's self-defense, and she's lying through her teeth, telling that she doesn't know anything, even the smallest of things of our life together, 4.5 years, and she does know. She knows it's self-defense, and she's been offered like $500,000 and might be a multimillionaire after this is over, and she's just keeping her mouth shut because she wants money. They have to have a conviction in order to get this money. And that's all I got to say. I'm not a serial killer.
Your Honor, we have some observations. I guess I should go first. Or maybe I could make some observations for the three of us. Mr. Tanner provided to Your Honor some personal views as to his understanding of his position here and the difficulty that he has, and I think that's legitimate. I really do think Mr. Tanner finds this role very difficult. Hasn't been easy for us either. It has been a difficult task when you're litigating over the life of a fellow human being. What I would suggest to Your Honor, and we will not go through aggravators and mitigators and rehash the evidence. Your Honor has heard it, and like Mr.
I need to speak again. Okay.
Yes, ma'am, you may.
Okay.
You want to wait till he's through, or you want to talk now?
I just wanted to make sure he wouldn't cut me off.
Go ahead now.
Okay. What I'd like to also say is that we had 2 clients that were willing to testify for me, that we did not bring the mitigator factors in, and I was surprised that my lawyers had me just testify on the stand and then said, the defense rests this case, because I did not know this was going to happen. We had a police officer that was going to verify that they misused evidence and that they falsified reports. None of the evidence, all the evidence on the floor, there was half of the stuff was mine. And there was a radio on the floor that one of the victim's family said, yeah, that's mine, and it isn't. It was our radio, and Tyra knows that. And I'm sure I could get a witness to verify that radio I had before Richard Mallory was ever killed. And I kept all the weapons in storage. None of the weapons were on the floor for proof, if I ever got busted, that I could prove that these guys used these weapons on me. None of the weapons were on for evidence. And we had 2 clients. We had a police officer. There was also, I had high school friends, at least 15, that I wanted contacted. They were not contacted. This case did not, for me to testify for myself, it seemed like I got a total raw deal. I should have had, my clients should have went up. That officer should have went up. I should have had my high school friends testifying for me. I couldn't believe I just got in that stand for myself. And I was telling the complete truth. I was being as honest as I could be.
Thank you. Mr. Nolis, you may proceed.
Yes, Your Honor. What I was going to say is just to give to Your Honor some personal observations.
Certainly.
Your Honor has a very difficult job here. You've been on the bench quite a long time, and you've seen, I dare say, quite a lot more than the three of us combined. It is a task that we do not envy, and that hopefully none of us will ever be in the position to make. I know I never want to be in a position to make the type of decision Your Honor needs to make here. We, as a people, can decide to impose the death sentence on Ms. Wuornos. We can decide to have her executed. Those procedures, as Your Honor know, are about as cold and calculated and premeditated, using those terms, as any procedures can get. It's done with a great deal of formality, with a great deal of calculation. What I would suggest to Your Honor is that such a sentence would meet none of the goals that we consider to be penologically appropriate. No one would be deterred by a death sentence on Ms. Wuornos. Surely rehabilitation is not at issue. And the only question is really retribution. And the question is it worth the thousands and millions of dollars that it's going to take to have Lee Wuornos executed? Is it worth us as a society? Is it something we should do? We can do that. If we were to do that, we will be doing something, and I would submit to Your Honor that we will be accomplishing nothing. And with that, Your Honor, I guess
Ms. Jenkins, Mr. Miller.
I have nothing to say, Your Honor.
All right, the defendant, Aileen Carol Wuornos, being before the court, attended by attorney Tricia Jenkins, William Miller, and Billy Nolis, her attorney of record, having been tried and found guilty of crime count 1 of first-degree premeditated murder and first-degree felony murder of Richard Mallory, a capital felony, and count 2 armed robbery of a firearm, armed robbery of Richard Mallory with a firearm, and no cause being shown why the defendant should not be adjudicated guilty, you're hereby adjudged guilty of said offenses. You will be, as required by law, compelled to pay $20 to Crimes Compensation Trust Fund and $5 in accordance with Florida Statute 943.25, subparagraph 4. I've reviewed your affidavit of indigency, find that you're unable to pay costs, and accordingly all costs are hereby waived. As to count 2, the sentence is imposed in accordance with the guidelines mandated upon this court by the state of Florida. The defendant, being before the court, attended by her attorneys Tricia Jenkins, William Miller, and Billy Nolis, having been adjudicated guilty herein, and the court having given you an opportunity to be heard and offer matters of mitigation of sentence, no cause being shown. The sentence of the law and the judgment of this court that you, Aileen Carol Wuornos, be imprisoned by confinement, committed to custody of the Department of Corrections for a term of 10 years from this date, with credit for times heretofore served in the Volusia County Jail. And you will be compelled to serve a 3-year mandatory minimum as provided by Florida Statute 775.0872.
So much bullshit. It doesn't matter.
As to count 1, you will be required to make restitution as entered by a separate order that I am signing at this time. As to count 1, the defendant, Carol Wuornos, being now before the court, attended by her attorneys, Tricia Jenkins, William Miller, and Billy Nolis, and having been adjudicated guilty of the crime of first-degree premeditated murder and first-degree felony murder, a capital felony, and the court having given the defendant an opportunity to be heard and to offer matters of mitigation of sentence and to show cause why the sentence of law should not now be imposed upon you, and no cause being shown, I'm filing with the clerk my written findings in this matter. Copies will be made available to the council when they're available. It is the sentence of the law and the judgment of this court that you, Aileen Carol Wuornos, be delivered by the sheriff of Volusia County, Florida, with a copy of this sentence forthwith,
to the proper officers of the Department of Corrections of the state of Florida, and by him safely kept until by warrant of the governor of the state of Florida, you, Aileen Carol Wuornos, be electrocuted until you are dead. And may God have mercy upon your court. The judgments and sentences will be entered in open court this 31st day of January 1992, and my signature attached. The court does not advise you that you have the right to appeal
That's
the
the only
judgment
part you need to
sentence
read,
imposed
bro.
upon you, and upon showing to the court of your desire to appeal the judgment and sentence.
Should be like, the rest of this shit, whatever. Electrocute you until you are dead.
For the
Get out of
appeal
here.
purposes. Will you please step over to the bailiff for fingerprinting, ma'am? This way, I think.
Gotta go fingerprint. We're gonna see it. Like, you're killing me. What does it matter? Sounds like a death metal song.
Mercy upon your corpse.
We've made it to the end. We've got about 30 seconds left. What a trial. Wasn't exactly what I thought it would be. I hated the judge. I hated the main prosecutor. I agree with the outcome. I agree with the jurors, honestly. And I know that the main, on October 9th, 2022, she was executed by lethal injection instead of electric chair. And I know the main thing it seems to be contended, at least in the chat, is the execution part of it. I know a lot of people are against execution. It sucks, man. But yeah, I think that they honestly, in my opinion, proved during the trial that she murdered some dudes, man, and had the intent to go out and murder some more dudes. But she also had a fucking terrible life, and it's very sad, and it sucks. Oh, damn, that's my green screen's off, I think. Is it? Oh, not far enough. There we go. Next week, we are going to start a brand new trial, ladies and gentlemen. I don't know what it's going to be. You're going to have to come through and see, because we're going to start it immediately, at least start it. Hopefully, we're going to at least try to get it started after we do the voting in the tournament. So right now, I've got, I don't even think I've got all of them yet, but I've got Pamela Smart trial, Daryl Brooks, Letitia Staunch, Chandler Halderson, Shantae Mallard, Ice Cream Man murder trial. His last name's Keatley. And then Urza McCandless. I think I got that right. So I think I still need to get another one. And if a few more trickle in, we'll figure it out. But yeah, anything you may think of, put it in the Discord. I'm going to put this in here right now. Drop it in the Discord and we'll see what's up. The only thing that I'm really worried... where the hell is it? Only thing that I'm really worried about is length. I just don't want to get trapped inside of another Spectre length trial, which shouldn't ever happen. Boom, putting the Discord in there right now. But yeah, the next time I'll be live, this stream should be taking you into a live tonight on my second channel, Wrestle Plunge. Wrestle Plunge tonight I'll be streaming 6 Eastern. We're right now in the year 1981 on Sundays. I like to travel around. We do a little time traveling on Wrestle Plunge. And on Sundays, we're in Southeastern Championship Wrestling. We're in the Alabama. We're in the Florida. We're in Tennessee, Virginia, West Virginia, a little bit. I don't know if we'll see any TV from there. Mostly the Alabama area for Southeastern Championship Wrestling every week. At least we're going to watch until about the second week of July or so. Exciting stuff. It's been fun to watch so far. And yeah, come through. If you do end up in that stream, please hit the like. It'll help me out. Get an extra like, even if you don't come back through later. Got Teresa saying the Chandler is a wicked trial. Okay. Got to come through and vote for it next week. I'll be live. Keep eyes on all socials. Chandler and Urza are good trials, says Brooklyn. Brooklyn, you got to come back in here next week. Again, I'm going to try to do a lot of promotion. I might even try to get a guest or two on here to try to get the word out. I'd like to get as many people in here voting as possible. And yeah, so hopefully we'll have a brand new, well, we will have brand new Murder Church season. And we're going into season 8, believe it or not. Pretty unbelievable. I've been doing this for 2.5 years now. Yeah, we'll be coming up, I think June-ish, May will be 3 years we've been doing Murder Church. And 1.5 years of that was one trial, Phil Spector. So that's what I'm not sure of. Make sure you're keeping an eye on everything. I'm not sure if it'll be 9 or 10 next week, but just keep an eye on Discord, X, YouTube, community, and I'll make sure that I'll let you guys know what's going on. But yeah, Aileen Wuornos, something that I've wanted to do since the beginning. Since we did Jeffrey Dahmer, our first trial. This was almost the first ever trial, and I'm really glad I did Dahmer first, I'm not going to lie. Dahmer's was very interesting to me. And Eileen's was kind of a letdown to me. I'm not going to lie. I don't even know how to explain it, really. A lot of it is because even if you're watching an old trial and you see something going on with the judge or a prosecutor like we saw in this one, if it's heavily leaned towards and you can tell that they're kind of, railroading the suspect or however you want to say it, the defendant, it can still be interesting to watch. Honestly, it can still get, contentious. There can still be some fiery moments, which is really what I'm kind of looking for. Because as I go, I'm learning still to this day. There's still things inside of these trials that I don't fucking know, So I'm a novice watching this. I love it when the chat gets in here. But at the same time, this one I wasn't a big fan of at the end of the day. But this one got the chat going. I know that early on, the chat was a little bit split. And as we went, I know the chat mostly seemed to be on Eileen's side. I think they, again, agreed with what was the jury's decision, but disagreed with the execution, which, I get as well. I definitely get the struggle with, state execution. Bob, I know, is against it. And I also get the worst possible thing that someone could do is live in prison for the rest of their lives. I get that argument as well. But also get the argument of execution and that fear once those days are approaching, and especially when you're on the table or in the chair. I would imagine that would be very similar to what you put a victim through, probably in a moment of distress and before that they are killed. I don't know. I'm rambling here. Thanks everyone for coming through. This has been another interesting project that we've taken on with Publicly Buzzed. I appreciate all the mods that have come through the last many weeks of doing this. And again, come next week, because the only way to know what Season 8 is going to be is because you're going to pick it. Thanks, everyone. I appreciate it. Let's go. I'll see you later tonight if you're coming over to Wrestle Plunge. Go hit the like ski over there.
This hurts.